Imagine someone comes knocking at your front door. They're from Child Protective Services, but no one accused you of hurting your child. There is no physical evidence, no witness, no confession. However, they tell you something so much stranger. A computer predicted that your family might become dangerous. Should this be enough? Should a prediction carry the same legal weight as proof? This question is no longer science fiction because it's already becoming our reality. Across the United States, child welfare agencies are turning to artificial intelligence to help screen abuse hotline calls and identify which children are at the greatest risk of being mistreated. Supporters believe that these tools can help overwhelmed caseworkers protecting vulnerable children. Critics argue that they disproportionately target the low-income and minority families because of how they heavily rely on public assistance. Both sides have focused on one question: how can we make the algorithms faster? But after researching this issue, I came to a different conclusion. I don't believe fairness is the most important legal question. I believe that we've been asking the wrong questions all along. To understand why this issue matters, we have to understand why these algorithms were created in the first place. Every year, Child Protective Services receives millions of calls reporting a possible child abuse or neglect. Every one of those calls can either represent a child in real danger or a family wrongfully accused. But with limited staff, limited time, and thousands of reports to investigate, agencies are left with an impossible task: deciding which of these cases requires immediate attention. So in order to help make these decisions, some child welfare agencies have turned to predictive risk modeling algorithms. These systems analyze large amounts of historical government data, such as prior child welfare involvement, public assistance records, and other administrative information, to estimate the likelihood that a child may experience some future neglect or abuse. The goal is understandable. If technology can help identify which children are at the highest risks, caseworkers can respond faster and potentially prevent tragedy before it happens. But here's where the controversy begins. Families living in poverty interact with government programs more often, not because they are more likely to abuse their children, but because they are in need of services like food assistance, Medicaid, and housing support. Those interactions create more government records, and when the algorithms learn from historical data, they can begin to mistake visibility for danger. In other words, poverty can become a proxy to risk. As a result, many civil rights advocates worry that these systems don't simply reflect inequality, they reinforce it. Families who have historically been overrepresented in the government databases may continue to receive higher risk scores. This creates a cycle where the same communities are being investigated over and over again. At this point, most discussions focus on one question: how do we make the algorithms less biased? And that's a reasonable question, but I don't think it's the right one. So who's affected by this debate? At first glance, it seems like there are two sides: technology versus civil rights, safety versus privacy, but the reality is much more complicated. So what have policymakers proposed? If you followed the conversation around AI, you've probably heard of these solutions before: better data, bias audits, transparency, and human oversight. And I want to be clear, these are all necessary. However, they are not sufficient because they're trying to fix the algorithm. I think we need to fix the law. When I began researching this topic, I thought the solution must be simple: make algorithms less biased, improve data, increase transparency, and require human oversight. Those ideas make technology better, but they don't answer the much bigger question: what gives the government legal authority to intervene in a family's life? Think about it this way. Imagine an AI system predicts that someone has an 85% chance of committing tax fraud next year. We wouldn't prosecute them. Imagine another system predicts that someone has an 80% chance of committing burglary. We wouldn't search their home. That's because we don't punish people based on what they might do. We require evidence on what they have done. So why should the standard be any different when it's about a government intervening in a family's life? This is where I believe the conversation has gone off course. We spent years debating whether predictive algorithms are fair enough. I think we should be asking whether prediction should ever carry the legal weight of proof. Those are two very different questions. An algorithm can estimate probability. It cannot distinguish proof. It can identify patterns, it cannot determine guilt, and it certainly cannot understand the full complexity of a family. Technology should help professionals find facts. It should never replace the facts themselves. So instead of proposing another technical fix, I'd like to propose a legal one. If I had the opportunity to place one bill on the legislator's desk tomorrow morning, this would be it. To address this problem, I propose the Child Welfare Predictive Analysis Reform Act. It's a framework designed to preserve the benefits of AI while restoring its one fundamental legal principle. The government intervention into a family's life must be based on evidence, not prediction. First, this act would prohibit predictive risk scores from serving as an independent legal justification for opening investigations, removing children from their homes, or initiating court procedures. An algorithm may inform a caseworker's thinking, but it may never replace the evidence itself to justify government action. Second, before any coercive action is taken, agencies must document independently variable evidence. That evidence can include medical findings, credible witness testimony, documented observations, or other facts that can be shown as evidence and be challenged. A prediction alone should never satisfy the legal standard. Third, instead of using AI primarily to predict which families might fail, the law should redirect these systems towards identifying where support is most urgently needed. If an algorithm can detect patterns with healthcare, housing instability, food insecurity, or barriers to mental health care, it should trigger supportive services, not heighten suspicion. In other words, AI should help families before a crisis occurs, rather than increasing the likelihood of unnecessary investigations. Finally, every family should have the right to know when an algorithm influenced their child welfare decision and the opportunity to challenge incorrect data or improper reliance on predictive tools. Transparency should not stop at the publishing technical reports. It should exceed to the families whose lives are directly affected. Together, these provisions don't eliminate AI from child welfare, they place it in its proper role, as a tool to assist professionals, not a substitute for human evidence or data. Of course, no public policy is complete without its critics. Now, I understand that not everyone's going to agree with my proposal. They may argue that placing legal limits on predictive algorithms can slow investigations and prevent caseworkers from identifying children whose lives are in danger, and that concern deserves to be taken seriously. Protecting children is one of the government's most important responsibilities. If AI can help save lives, then we should not ignore its potential just because it's not perfect. But my proposal does not ask us to choose between technology and child safety. It asks us to distinguish between assistance and authority. Artificial intelligence should absolutely assist caseworkers by helping them organize their information, identify patterns, and direct supportive services to families that need them most. What it should not do is provide the legal authority for government intervention into a family's life. Technology may help us predict risk, but in a society governed by law, predictions cannot replace proof. By preserving AI as a decision support tool rather than a decision-making tool, we protect both children and the constitutional principle of families. And that is exactly what a good public policy should do. At the beginning of my speech, I told you to imagine a family getting a knock at the door. The question was never whether AI can calculate risk. The question was whether a prediction should ever be enough to justify government intervention. And the answer is no. Artificial intelligence can predict possibilities. The law must protect people. And in a child welfare system committed to justice, those two responsibilities should never be confused. Thank you.